Okay, welcome. We're just letting folks in from the waiting room right now, so give us a few moments and then we will be getting started. Okay, so welcome. This is the webinar. It's our monthly series titled Divorce Foundations, and it's a 101 guide to Washington state laws and what to expect with divorce and family law. So I'm going to introduce myself briefly. My name is Melissa Rosenberg. I'm actually a therapist and I work here in Seattle, Washington in private practice. One of my specialty areas is working with clients who are navigating different stages of the divorce and separation process. I work with both individuals and couples who are in this space, either early side of trying to determine if divorce or separation is the right fit for them or not. Also, if clients are in the middle of a family law case, there's generally a lot of emotional implications. And so I work with clients in therapy and processing those things. And also on the other end, when people are really just trying to kind of navigate their next chapter. It's one of my specialty areas, but today I'm here as a moderator for this webinar. And so in a moment, I'm going to transfer it over to Michelle and she'll be taking the reins and providing lots of great information. But I wanted to just give you a moment of kind of intro about what to expect in the webinar. Michelle's going to deliver a lot of great information about, just divorce in general and all the 101s that you need to know about family law and what to expect here in Washington state. But we also want to answer questions that you might have for the people that are here on this webinar. So the way that you can pose questions are in two ways. There is a question and answer button at the bottom of the Zoom screen, as well as a chat. If you pose a question in the question and answer, it will show up with your name, but you can also choose to make it anonymous. And if you pose it in the chat, it's set up so that attendees can just only chat with the host, so it'll come directly to me. Either way, if questions come in, I will filter them to Michelle. We'll try to get as many of them answered as we can during this hour. But I also want to just kind of let you know that we can't answer very case-specific questions. They need to be a bit more general, or we won't be able to field them. Do as best as we can. All right, with that, I will turn it over to Michelle, and we look forward to delivering some great information today.
Hi, I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we actually help clients all over Washington state. So I've been practicing family law for over 16 years. So we've seen pretty much everything from highly contested litigation cases to mediation to uncontested and cooperative settlements. So there's a lot of different approaches to divorce, and I've seen them all. But what I'm going to do today is talk about some basics so you understand divorce in Washington state. What is it? What does it mean? What are the main issues? This is meant to be a very base level, informative, foundational series for you. So we do have special topics that we do every month that dives more into individual topics. So I'm going to go over some basic information for you today. And like Melissa said, we will take questions. It's important to note that I'm an attorney, but I'm not your attorney. And I am not providing you legal advice today or tax advice. I'm providing you information. So if you do ask questions and they're very fact intensive, specific questions, Melissa will probably try to parse out the general legal issue in the question, but I'm not going to be able to answer really fact-intensive questions. But I'll do my best to get you some information, go over the basics of Washington divorce, and we'll go from there. So what I like to start with is what is required to file for divorce in Washington? Like, who can file? What does that mean? Do you even know? Can you file for divorce if you lived here for a day? Can you file if you moved here from another state? What does that look like? So the most basic thing for you to know is there is a residency requirement when filing for divorce in Washington. At least one spouse must reside in Washington state at the time of filing. And this is the thing about Washington that's different than other states. There's no minimum residency period, meaning a spouse can file immediately after moving to the state and establishing residency, which is really easy to do in Washington. You can go and get a driver's license, open a bank account, and you're a resident of Washington like that day. There's no waiting period. However, if one spouse doesn't live in Washington and never lived in Washington, you really do need to talk to an attorney to understand if there is what we call jurisdiction over the other spouse. Now, what does that mean? Well, I'll give you an example. If you moved to Washington from California and you and your spouse had never lived here and your spouse has never been here, jurisdiction means the court's ability to enter an order pertaining to that person. So Washington court doesn't have any authority over your spouse. However, if you and your spouse lived here, then you moved to California and then you moved back, there would be jurisdiction. So it can be a very fact-specific analysis. It's also important to talk about jurisdiction over your children because that's totally different. Jurisdiction over your children, meaning where a parenting plan or child support order can be entered, is going to pertain to where your child has lived for the last 6 months. So there's not going to be authority of a court to enter a parenting plan with respect to your kids or make decisions about where your kids are going to live if your child hasn't been in Washington for 6 months. There are some exceptions to that. There is the UCCJEA, which is the Uniform Child Custody Jurisdiction Enforcement Act. You don't need to remember that acronym, but it is basically the law of the land that pertains to where custody is for children. And there's exceptions. If you flee to Washington to get away from a domestic violence situation, that would be one. Washington could potentially take emergency jurisdiction for a period of time. So there's a number of different things that apply. But the main takeaway here is move to Washington and you can file for divorce. It may or may not be able to comport with the jurisdiction over the other party or your children. We don't know. So next thing, grounds for divorce. Do you have to have a reason to file? Who can file for divorce and what does that mean? So Washington is what we call a no-fault state. Most states now are no-fault states. What that means is you don't have to prove that anybody did anything wrong to file for divorce. If you don't want to be married anymore, you can file and the other person can't stop you. In fault states, you might need to do something like prove adultery or prove some other kind of thing. There's only a few states that do that, and we are absolutely not one. Anyone can file for divorce. It's a no-fault state. That also means that fault isn't taken into consideration. Like if someone commits domestic violence or if someone, has an affair, you're not going to get more money just because somebody did those things. There might be situations where if somebody took money from the community and did other things with it, maybe you can get money for that. But basically, we are a no-fault state, and fault is not going to be a reason to allocate more money to somebody. The only required ground in Washington is that the marriage is irretrievably broken. So those are the words you will see in every divorce petition. It says the marriage is irretrievably broken. I've had a lot of clients say over the years, I don't think it's broken. I don't want the divorce. I want to say no. But I mean, if you're doing that, I understand how you feel, but you're really not doing yourself any favors because you can't, if one party thinks it's broken, it's broken. You can't force somebody to stay married to you. Next thing, waiting period. So we've talked about who can file for divorce in Washington if you live here. We've talked about what are the grounds? You don't have to have any. It's a no-fault state. And now what about the waiting period? How long does it take? Everybody wants to know that in the beginning. How long is this going to take? How long is my case going to go? Well, there's a couple different ways to look at this. The requirement in Washington is we have what's called a 90-day waiting period. Now, there's no waiting period for legal separation, so that's different. But in a divorce, there's a 90-day waiting period, which means after filing in service on the other party or the other party signing what's called an acceptance of service, there's a 90-day waiting period before a divorce can be finalized. So on the 91st day, if you guys have agreed orders, you can go ahead and present those and finalize your case. But you can't do it like if everybody agrees on everything a week later, you have to wait the 90 days. It's a required cooling period. Most of the time, though, what's reality and what the 90-day period is are totally different. Even cooperative divorces where people are getting along, where you have to figure out a parenting plan, you have to divide financials, you have to value some assets. A typical divorce is going to take you 6 to 9 months. That's just reality. Something that is a little more either litigated or there's more complex financials or parenting issues might be, 9 to 18 months. I mean, those are just estimates. In King County, there's a case schedule that sets out deadlines in your case over the course of a year. So sometimes things don't happen very quickly. But if everybody really agrees on things and you want to finalize, Washington has a 90-day waiting period. So that's the big takeaway. Okay. Now before I get into the 4 main issues of divorce, I'll take any initial questions.
Yep, we have one question off the bat here. Participant saying that the moneyed spouse or the person with more financial backing has mostly separate assets. How does the community get decided after a 19-year marriage for a stay-at-home mom?
That's a good question. Well, you're in luck. The first thing I'm going to talk about is asset and debt division. That's the number one topic. So I'll use your question as a little bit of a guide. I'll give you the basics on community property and separate property, and then we'll talk about how communities are typically divided. And you said you have a 19-year marriage, one party has mostly separate property, and one party is the lesser moneyed stay-at-home spouse. Okay. I'll address that, but I'll go over the basics first, and you can actually probably figure it out. So community property and debt division. It's important to talk about that we are a community property state. If you're here and you're watching this, you probably know a thing or two about divorce. You're not a total beginner. You've probably heard community property. So let's talk about that because it has to be decided in every case. What is it? What does it mean? What is community property? Community property also pertains to debts. And what it is any asset or debt that is acquired during the marriage. It can also mean any asset or debt that is acquired in the period before the marriage, but that's another question. That's another issue. Let's just keep it simple and say it's any asset or debt that's acquired during the marriage. Doesn't matter whose name is on it. What that means is that is community property. It's community asset or it's a debt. And it also means that both parties have an ownership interest, regardless of what the name is on title. So let me give you an example of that. If you go to work and you work there for a number of years and you have a 401k that you're contributing to, and maybe your employer's matching it, maybe they're not, that accounts in your name. But if you work there and you put money into it during the entirety of the marriage, your spouse has probably an equal right in it as well. They have a community interest. So both you and your spouse have a community interest in that 401k, even though your name is the only one on the account. The name on title doesn't matter in a situation like that. So it's very important for you to know. Everything that is acquired, whether it's a debt or an asset, is presumed to be community. And what that means is there are some things that are going to be taken out. So if you inherited money during your marriage and you inherited it, just you, not you and your spouse, and you kept it separate by operation of law, which means even without other prior agreements, that inheritance is going to be yours. If you were gifted money, and again, you gifted money, not you and your spouse, the presumption is that that gift is just to you, and that's not community property. Another good example of what's not community property that's acquired during the marriage are assets from a separate property, business, or rental property. And these are just the common ones. There could be other things. So if you had a rental house, you owned it before you were married, and now you're renting it out and you're making income on it. Well, you're making that income during the marriage, but it comes from a separate property asset, so that's your separate property. If I have a business and I started that business before my marriage, the money I make absent maybe some reasonable wages, but most of that and the ownership of the business is separate property. So there are exceptions, but generally speaking, big picture, anything that you earn or any debts that are taken out during the marriage means both parties have an interest in it. Here's the other big takeaway for you. We are not a 50-50 state. A lot of people think that everything gets divided down the middle 50-50. This is where when someone's asking about a 19-year marriage, it really comes into play because in some states like California, they're a 50-50 state. So in a California court, nobody cares if you're married 19 years or 9 months. Everything you have is going to be divided 50-50. That's community. Washington, we don't work that way. We are what is called a just and equitable state. Those are kind of the magic words. Just and equitable, what does that mean? In theory, it's supposed to mean what is fair. Well, if you've ever watched anything that I've ever done before, whether it's a webinar or a meetup group or anything else, or you've ever talked to me, I will tell you, forget about the word fair. Like people are going to say what's just and equitable is supposed to mean what's fair. Your idea of what fair is going to be 180 degrees different probably from what your spouse thinks is fair. Like they might think, oh, I went to work, I earned that money, you didn't have to work, it's fair for me to keep it. That's just. Well, you don't think that. There's only two kinds of fair. One of them is what you pay on the bus or the light rail or you put on Orca card, right? That's a fair. Like you actually pay it and you can know how much it is worth. The other one they have at the Puyallup or at the Evergreen every year and you get to go on rides. That's it. Fair does not exist in your divorce, so just don't think about it like that. Think about what just and equitable means. It means how long you're married, and what is the financial situation of the parties at the time of your divorce? That's what's going to determine how that community property is divided. You're not going to think it's fair. They're not going to think it's fair. It's going to be a compromise. And it's going to be based on how long you're married and what your financial situation is. Okay. So separate property, and this person had asked about in their question, the other spouse has primarily separate property. Well, that would be property owned before marriage, inheritance, or gifts. If that's the case and it's all separate property, it typically remains with the original owner. But here's the thing to know. We like to say this phrase, and you might hear it if you're in a divorce case eventually. all property is before the court. What that means is the court's going to look at how much separate property each party has. They're going to look at how long you're married. They're going to look at the financial situation of each spouse. They're going to look at the contributions to the marriage, including homemaking. This person was asking about that. They're going to look at your future earning potential. And they're going to look at it and they're going to be like, how do I do equity? Which means, how do I supposedly do what's fair? Well, I look at the big picture. That's what a court's going to do, and that's what your settlement's going to do. So if one party's sitting over here and they've got, let's just use round numbers, $1 million in separate property, the other party has none, and then there's a community of $1 million to divide. So if you split the community in half and you gave one person 500,000, the other person 500,000, they've got 1.5, this person's got 5, right? Could that happen? Yes, that could absolutely happen. However, in a 19-year marriage where one person has stayed at home, that's probably not going to happen. What usually happens is the lesser moneyed spouse in a midterm marriage, typically, depending on the situation, gets a disproportionate property division if there is a significant discrepancy in your income and your earning potential. So let's say one person hasn't worked in 10 years, they've been married 20 years, that person might get, I mean, these are just numbers to throw out there, depends on how much your community is worth and the circumstances. Maybe they're getting 60% of the community, maybe they're getting 55%, maybe they're getting 70%. I don't know, I need to know more. But the point is, disproportionate divisions can be made. Now, here's another thing to know. In long-term marriages, and in Washington, a long-term marriage is 25 years or more, there is case law in Washington that allows the court to do what we call invade. And invade sounds scary, and it actually, in fact, is. Invade separate property. So if I have separate property, and I've been married more than 25 years, the court could divide that separate property to do what's fair and to make everybody equal. That could happen. That's not going to happen in a marriage less than that, but the court could say, hey, one person has $1 million, the other person has none. I'm going to give the other person way more of the community to try to make them equal. They just can't touch that other person's separate property. So as you can see, there's a lot of hypotheticals and there's a lot of things to know. The takeaways about community property, we're not 50-50. We're just inequitable. Just inequitable division looks at duration of marriage, financial situation of the parties, contributions to the marriage, and earning potential. It's going to be a very fact-specific question. What is community property? Community property is presumably anything that's earned during the marriage, absent separate property contributions, investment or gifts, debts as well. So that is your main takeaway about community property. So this person that's married 19 years, and there's a bunch of separate property on one side and they stayed home, hopefully you can get some kind of a disproportionate division. Also, you might be able to get disproportionate division, or maybe you're looking at property division plus spousal maintenance. It really depends on how many working years are left for either spouse, what your age is, what the other party's income situation is. So Washington is what my friend Kim Muska calls a choose your own divorce adventure state. So you can structure your settlement however you want. No one's going to care. You could say, I'm going to get more property and not maintenance. I'm going to get less property and maintenance. I can do a combination. You can do a lot of different things to do supposedly what is just and equitable. So that's something for you to think about. I'm going to move on and talk next about parenting. But before I do, is there any questions?
Yep, couple questions. This is a question, I feel like it comes up a bit in different ways. They're saying 28-year marriage, spouse is hiding assets at other people's property. Is that allowed? If not, what can you do? I don't know what they mean by hiding it at other people's property, but hiding assets in general is something that seems to be asked about a lot, you know. So what can you do if you think somebody's hiding assets?
Well, here's the thing, and I don't mean to be negative or trivial about it. We hear all the time, so-and-so's hiding assets. Number one, how do you know? You don't, unless you can show me, then they're not hiding, right? And number two, you need to understand that you might think that, and maybe it's true, but it doesn't happen that often. And it's difficult for people in an electronic era to hide assets. So what that means is you're going to get disclosure. You're going to get full financial disclosure of debts and assets from the other party. You're going to get to see their financials on all their accounts. You're going to get to see tax returns. You're going to get to see all of that. And I can look at a tax return and tell you a lot that you don't even know about what people have or what they don't have. It's really difficult to hide assets. You're going to pull a credit report. You can do that and see what accounts are. This is almost impossible unless you're a cash business. If you're a cash business, sure, you're putting money under a mattress. That's one thing. If you're moving money off Sure. Well, that's another thing too, but then you're going to be able to see wire transfers and things like that. Very difficult to hide assets. What do? We send discovery requests. Discovery requests require that you provide access to all of your financials. There's a ton of questions. They have to answer them within an amount of time. If they don't, we also have subpoena power. We can send a subpoena to financial institutions. So there's a lot of things you can do like that. Sometimes people will say, oh, they're not hiding, they're hiding physical things, or hiding like jewelry is a really common one. They're hiding jewelry. Well, that can be more difficult, but like if it's physical and you can prove that you had it, then the question becomes, well, where did it go, right? And so then you can ask discovery questions to address what happened to that property. And then if someone sold something, sometimes someone will sell something, well, where'd the money go? So there's a number of things. It's a paper trail, but it's not like a one size fits all answer. And as what I would call, you're a litigant if you're involved in divorce. So you're a litigant. And I'm gonna tell you this now, anybody that's watching this, be patient. Okay, like no one's going to have a magic wand and all of a sudden your case is going to be solved. If you think someone's hiding money or assets, it's going to take some due diligence to uncover that. And this is where you really have to think about, is it worth my time and money? If it's a lot of money or a big deal, then yes, it's totally worth it. But you're going to pay attorney fees, you're going to have your time, your emotional, there's going to be an emotional toll. If it's a small, what I would call de minimis amount, then you need to think about, is it worth it for me to throw good money after bad and try to chase after something? If it's a ton of money, yes. If the return on investment is there, yes. If it's not, if it's something small, I once had people spend 9 hours fighting largely over a movie poster collection. That was not a good return on investment. So sometimes I'm saying that with respect to what I would call stuff, you have to let it go. And, I'm not talking about valuable jewelry, I'm talking about sentimental things. So that's something else to keep in mind. And that comes up a lot with hidden assets. So very good question. I will touch now on the two issues that you have to deal with respect to children. One is parenting, and the next is child support. So we have other webinars that talk about parenting. And so I'm not going to go into a lot of detail, but what I am going to tell you is that if you have children, you will have to have a final parenting plan entered in your case to be able to finalize your divorce. So that parenting plan is going to deal with the residential schedule. Where are the kids going to live? It's going to deal with vacation schedule. Where do the kids live during the summer? It's going to deal with the holiday schedule. Where do the kids go on holidays? How do you split that time? It's going to deal with decision making, which is a really big thing in parenting plans. Who makes decisions for the kids with respect to non-emergency medical, education, extracurriculars? Typically, you have to agree on those kinds of things. What is the process for decision making? How does it work? What happens if parties don't get along? What do you do then? Like if you guys don't agree on a joint decision, what do you do? Typically, you'll go to mediation or arbitration. In some cases, you'll go right to court. It's going to lay all of that out for you. All of these things are in a parenting plan, which is very important. What kinds of schedule is your kid going to have? Well, that's going to depend largely on the circumstances of the parents, their ages of the children, where you guys live. All of those kinds of things are going to come into play. But a parenting plan is a court order, and it's going to be required in your case to finalize your case. If you can't agree on a parenting plan, which is not uncommon, you may have a custody evaluation take place. So that would typically involve a guardian ad litem, a parenting evaluator, family court services, CASA, which are court-appointed special advocates. There's a variety of different ways you can have an evaluation done if you need that to happen. And either party can typically motion for that. Sometimes the court will ask for it on its own. So anyway, parenting plan is a very, very big issue. Child support, I'm going to touch on that briefly as well. Child support is required. You have to have a child support order. A lot of clients will say, I don't want any child support from them. Well, fine, but you still have to have an order. And there's two things that the court does have the final say over. The court doesn't care if you give 100% of your property to somebody. They're never going to intervene in your property settlement agreement. They're never going to intervene in your spousal maintenance issues. They are going to be the final say on a parenting plan or on child support. So you can't have a parenting plan with somebody who has a domestic violence and criminal history, typically being a primary parent of the child if it's dangerous for the child. Court would stop that. You can't have a plan that gives no decision-making to a parent unless there's a reason and it's articulated. There's a lot of things like that. Child support. You can't say I'm going to have no child support unless there's a basis for it that the court agrees with, because the court has an interest and the state has an interest in making sure that children are taken care of. So you can agree to no child support, but the facts are going to need to support that. A child support payment is typically made from one party who has the children more nights to the other, I'm sorry, one party who has the children less nights on the residential schedule to the party that has the children more nights. And that payment is going to be based on the income of the parties. And there's going to be a statutory calculation, and then it gets allocated between the two parties. One party makes 75% of the income, they're going to pay a higher amount to the other party. And then things that are not covered by child support. Child support covers shelter, food, included activities, things like school lunches, all that kind of stuff. That's what the main child support transfer payment covers. Also covers like gas, transportation, basic living, and required expenses. What's not covered are out-of-pocket medical copays, meeting deductibles, extracurricular activities, things like that, work-related daycare, those things are not covered. So those things are going to be divided based on what that proportional share of the income is. And I know this sounds really complicated, and it is when you see it on paper, but once you understand it, it really is kind of, child support is basically based on the numbers, and it is the least complicated part of your case. I know that might sound unlikely, but it really is. So anyway, we've talked about property division, parenting plans, child support. The last thing, and then I'm going to circle back on some of this and take a few more questions, is spousal maintenance. In every case, you're going to have to decide, is one party paying spousal maintenance to the other? And there's not going to be spousal maintenance in every case. There just isn't. But there's going to be a question of whether somebody's paying it. And how do you figure that out? Well, again, you look at the length of the marriage and you look at the financial situation of the parties. So if you're in a short-term marriage, which is usually 5 years or less, it's very unlikely that parties are going to be paying post-divorce spousal maintenance. If they are, very minimal, less than a year, and there would have to be a reason or a big discrepancy in income. If it's a midterm marriage, 6 years up to about 24 years, there's probably going to be maintenance if the parties have disproportionate incomes and there's not a lot of property to divide, or even if there is property to divide. So it's going to depend on length of the marriage, financial situation. Maintenance is typically awarded on 3 or 4 years of marriage to 1 year of maintenance. So that's just a rule of thumb. That's not a calculation that you can count on. It's also going to be fact specific, but that's a general guideline. So that's a little bit about spousal maintenance. I have a feeling, since I've been talking a while, there's probably a few questions, so I'll take some of those and then I will continue on.
Yep, got a handful of questions here. Okay, let's see here. This person's asking, in a 3-year marriage where the DV was involved, and they're talking about emotional abuse, financial abuse, and psychological abuse. This person and was arrested and was willing to agree to a 1-year protection order. So that's a part of the picture. They're wondering about how long they could possibly get temporary spousal support, and if that's
In a 3-year marriage?
Yeah.
Probably not very long at all.
And is the relationship to the DV claims?
No,
Okay.
no, highly unlikely. And that's, first of all, really unfortunate if you had to get a protection order and you were in a DV situation. That's really unfortunate. And I'm sorry, because you've obviously been through a lot. But you're not going to get maintenance based on a protection order. You're just not. They actually can't do that. So that being said, temporary spousal support, this is a good opportunity to talk about temporary support versus post-divorce support. So temporary support is basically a temporary status quo, basically saying one party pays the other spousal maintenance on a temporary basis while your case is pending. Can you get that in a short-term marriage? Yes, you can. But courts are hesitant to give temporary support unless there's a reason, or sometimes they'll limit it. I had a case not that long ago. I think it was a 3-year marriage, maybe 4, but I don't know, it doesn't really matter. It was somewhere between 2 and 4 years anyway. And the court said, okay, fine, other party needs some money while they get on their feet or whatever, but they limited temporary support to 6 months. That's not uncommon. So it also depends on the county that you're in, but in King County, most courts are not fans of having lengthy or indefinite temporary support in a short-term marriage. And the reason why is that in a short-term marriage, the thinking on that is really that the parties haven't relied on the marriage long enough to need that support. So it really doesn't matter what happened during the marriage. It matters the length of the marriage. So really, generally speaking, Washington courts follow short-term marriages very little temporary support. It could happen though. I mean, it just depends on the circumstances. It doesn't mean not to try, but you need to understand that when you seek temporary orders or temporary support, there's going to be a cost to you for that too. And then we'll talk about attorney fees in a minute because you may be able to get some of that covered. But you want to be smart with your money. That's what I tell people. You don't want to throw good money after bad, kind of like I was talking about with the property division.
Thank you. Okay, another question here. Once one spouse has been served with dissolution of marriage papers, is any income earned by any party thereafter prior to the finalization of divorce, is that separate property? What happens in between
Yes.
period of time?
Yes, generally speaking. And like I said, let's keep in mind that all income and all assets are before the court. So the court's going to know about it. But like, let's say that, and divorce can take a while, like we talked about, but generally data separation establishes the end of the community. So there's no community once you're separated, once somebody files for divorce, there's no more community. So any money that you're making is yours. Any money they're making is theirs. That being said, if one party takes a year to get divorced and one party gets a whole ton of money, right after that, number one, they might be paying support with it. That's very likely. But number two, it's going to be taken into consideration in the overall picture of, hey, this person has this much money, this person doesn't. But yes, data separation establishes the end of the community. So assets and debts after that separation, that filing and service, after somebody files for divorce, it doesn't even have to just be filing for divorce. It can be somebody moving out and establishing a data separation and no longer working on the marriage. But yes, that establishes the end of community property. That's a great question.
Yeah, great. Okay.
I'll take one more.
Okay, got a bunch more. Let's start this one.
All right, I'll take two.
Okay. Inherited mother's retirement plan after spouse and I separated. We'd been married over 27 years when we separated and was a stay-at-home mom for a large chunk of that. Spouse makes 10 times what I make and has proposed no spousal support due to the inheritance.
Okay. Well, I mean, I
Yeah,
hope you have an attorney. If you have a
yes.
I hope you have an attorney. If you have a long-term marriage, I mean, anybody needs an attorney. I'll tell you why in a few minutes, not just because I am one. And I don't care if it's me, but you need to get one. I would never tell a friend or family member, especially in a long-term marriage, or even if you think you don't have anything, to go through a divorce without at least some legal advice. In a long-term marriage, especially because this is going to set you up for the rest of your life, really. You don't have a lot of working years left. If you have an inheritance, especially, you need to protect that. That's up for grabs in a long-term marriage, because even though you might have gotten it post-separation, all properties before the court in a marriage of 25 years or more, your separate property could be invaded. So that's really important. But also, it's fact specific. How long is your spouse going to continue working? How old are you? What are the Social Security benefits? What are the retirement benefits? Like, there's a lot of factors that are going to contribute. But if the court is saying, oh, I mean, if your spouse is saying, I'm not going to give you spousal maintenance because you have all of this separate property, that may be valid or it may not be. It really depends on how much it is, what's the community worth. There's a number of factors to consider. You really need an attorney. So that's all I can tell you. It's not an automatic, though, that you won't get spousal support, but it's also not an automatic that you will or that your separate property isn't an issue. So.
Great, that's helpful.
Yeah.
Another question, they're saying their spouse ran up a large amount of debt after we separated. I'd removed myself from all the joint accounts when we separated, found out he was spending lots of money, having an affair, etc. Am I still responsible for half the debt he accumulated after separation?
No. I mean, no. If it's after separation, it's his debt. It's on him. It's not your problem anymore, which is a good thing. So good job. Yeah, good thing.
You want to do one more?
Yeah, I'll take one more.
Okay, my spouse and I have donor eggs being stored, not embryos. Are these eggs also considered community property? Is ownership typically split when a couple divorces?
Yeah, I get this question a lot. Yeah, I mean, it's community property. It was acquired during the marriage. It's both of yours. However, here's the thing. Depending on where, I mean, assuming it's in Washington, just assuming that. If so, there's going to be an agreement with whatever facility you used, whoever's storing the eggs, and typically requires consent of both parties to do anything with them. So typically one party's not going to be awarded them. They're probably going to be destroyed if you guys can't agree, which is typically what happens in a divorce, and that's likely what the agreement says. So comes up a lot, but yes, they are community property, but the court is going to follow whatever the agreement is that you guys signed because that's a legal contract. So I hope that helps. I did want to talk about briefly attorney fees because that comes up a lot. So generally, attorney fees in Washington can be awarded based on need and ability to pay. If one party has a need in a divorce action and the other party has the ability to pay, there is statutory law and case law in Washington that allows for attorney fees to be awarded. So like person that's talking about the other person making a bunch of money post-separation and they're not, or they're a stay-at-home parent and they don't have access to money, other party's probably going to have to pay some attorney fees. However, it's not a given, and it's going to depend on what the other party's ability to pay is. Like you might have a need, they might really not have the ability to pay, especially if they're paying all of the community bills. So it really depends. But it's not uncommon in your case, especially at temporary orders in the beginning, for one party to ask the other party to give them attorney fees to get them in the case. That's completely fine and fair and happens all the time. Or the other thing to think about is this: one party having an attorney and having someone and the other party not is probably not going to happen. The court's probably going to award some fees so people have level playing field. Both people need representation. I said it earlier about needing an attorney, and I really think this is important. Like, I know a lot about a lot of things. I know a lot about tax from doing divorce for 16 years. I know a lot about financial planning, but I don't plan my own financials and I don't do my own taxes. I go to somebody that knows better than me. Right. And, just in the same way that I would not perform surgery on myself, if I hurt myself, I would go to a doctor. You need to understand that a marriage or a legal separation, whichever action you decide to go with, a marriage is the most involved legal contract that you're ever going to have with another person. And you didn't have to get a lot of education to enter into it. Basically, you had a party, you said, I do, everybody had a good time, probably had something to drink. Time goes by, and now you are financially tied to this person in a way that is not like any other contract. And so it would behoove you to have help understanding what your options are. I've had people come to me where they really mean well, and they're like doing what we like to call a DIY divorce. Maybe they even went to a mediator who was a neutral and tried to help them work some things out. Then they have an agreement and they bring it back and they're like, hey, we need this drafted up. And I'll say, okay. So I look at it and someone says, hey, he agreed to split everything 50-50 with me. It seems so fair and that's great. And it's like a longer marriage and they've got a bunch of assets. No way a court would ever do 50-50. That's like a home run for him. And you just left hundreds of thousands of dollars on the table because you should have had 60%. And then guess what? We're back to square one. And that, or they don't come and talk to somebody, they just sign something and they agree to like almost no spousal support, or they agree to be paying. I've had the other side of the coin where someone's paying a ton of spousal support and giving the other party everything because they feel bad because they had an affair or because they think that's what they should do. And it's never what a court would do. So you really need some guidance to make sure you're either not giving up too much or you're getting what you're entitled to. Basically, so you're getting that just and equitable settlement. I can't stress it enough. Do you need an attorney? I mean, yes, you need somebody to explain Washington law, procedure, the case flow, the options for strategy, and help you set the strategy. You need somebody to give you basically even what you don't want to hear about your legal rights and obligations. You need to understand the reality of asset division, spousal maintenance, parenting plans, and child support. You need help probably identifying and classifying what is marital property and separate property. You might need to engage in the discovery process. If you think someone's hiding assets, you need to be able to serve discovery, serve subpoenas. You might need somebody to work with experts to determine how much is your home worth, how much are your restricted stock units worth, which part of those are community, which part is not, what about your business, what about your investment. You need somebody to propose and negotiate asset division, including real estate, retirement accounts. You need somebody to handle the disputes over agreements. So there's a lot of things like that that you should not be dealing with. And if you are, it's going to take over your life. And I don't care how much you try to use ChatGPT, you're going to get it wrong. Like even non-family law attorneys get it wrong. In the same way that if I have an employment law issue, I don't try to figure it out myself, and I'm an attorney. I get an employment law attorney. So you need somebody that really does divorce. Don't go to somebody that does 5 different things, because I promise you they don't speak the language the way a divorce attorney does. So that's one thing to think about. If you have kids, you need somebody to advocate for your rights related to parenting time and also to tell you what makes sense and what's age appropriate. Everybody likes to talk about a 50-50 parenting plan. Does that make sense? Is that likely? Everybody likes to talk about whether somebody should be restricted from time with the kids. When does that happen? What's the basis for that? Everybody likes to talk about maybe I need a guardian ad litem or a parenting evaluator. What's the difference? What does that mean? You need help on that. What about decision making? That can be something that you're going to have to deal with the other parent for years to come. You need to understand what the best protocol is for that and what your options are there. Same with child support. You need to figure out what expenses should and shouldn't be covered and how those are dealt with. Same with spousal support. So there's a lot of things that need to happen. And it's important for you to know that you can get through all of these things. And you really should try to be living your life, supporting yourself, taking care of your kids, and just getting through this the best possible. I like to tell people this, and it's so true. If you don't have a therapist, you should get one. A couple reasons why, and not just because Melissa's on this webinar, but she will tell you like a couple reasons why. Number one, people talk about how expensive divorce is. And it's not like that we don't care. Attorneys, we care. We care what you're going through. But you're going to spend a lot of time and money, and a lot of clients spend a lot of time and money being really upset with their divorce attorneys and like talking emotionally about what's going on and looking for solutions. I'm not qualified to tell you that. I'm not in any position to help you with that. I want to hear about it, sure, but I can't help you, and it's not a good usage of your money. If you have if you have a therapist, they're going to help you be prepared to get through your case in a way that's more productive and cost effective for you. I mean, that's just the reality of it. And I can tell you too, as somebody who's done a lot of high conflict custody litigation, if you have a therapist and you're in a custody situation and you're taking care of your own mental health, that actually looks good for you and it's helpful for you. And you have to worry about your kids in addition to yourself. So you're going to need that extra support.
Absolutely. Okay, a few more questions. This person's saying that they're thinking of doing a GoFundMe for divorce and expenses. Would my spouse be entitled to half of that, or should I wait until the divorce is over to do the fundraising?
Well, a couple of things. No, if it's post separation, that your spouse is not entitled to that, but it could be used against you. I've seen GoFundMe pages. There used to be another one, not GoFundMe, but used as exhibits. Oh, this person said this or that in there, or someone said this or that on the GoFundMe, and people could construe that a certain way. I would wait till your case was over, just because you never know. Anything that's online, you never know. I would wait till it's over if you can.
Okay, thank you.
And well, you know what? I'm going to say also too, not just about that, but social media in general. I'm going to say this, and I would not post anything about your divorce on social media, even if you think your account is private. You might think, oh, my Instagram's private, my Facebook's private. I don't even know what other social people are using these days. I know there's a lot of it. My TikTok, whatever, right? You don't know who's connected to who. You don't know what's going to get out there. I have seen social media as exhibits in divorce so many times, things taken out of context that you wouldn't want. Lock down your social media. And not only like don't talk about your social media, but think about what's on there. If you have a picture of you taking shots in college 15 years ago and it's on your Facebook, that could appear so-and-so has a drinking problem. See Exhibit A. Like, and then you have to explain it. It's just like, lock down your social media. Don't post about your divorce on social. Also think about your online presence. If you have things online that, tell about you personally, just figure that it's all fair game and it's up for grabs. And if one person can find it, anyone can find it. So that's something for you to think about. Just be very careful. That's all. And I know it's terrible to have to say that because you probably have stuff out there that's not bad, but could be misconstrued. And I just don't want you to have to deal with that. It'll cost you time and money and stress that you don't need.
Totally. Yeah, there's a lot, right? I mean, you're talking about kind of having therapy support, and I think it is really important to have some person to kind of, help you process what's happening. Certainly doesn't have to be me, but like I just wanted to pick up back on what Michelle was saying earlier about that, essential nature of having the appropriate support, the appropriate attorney support, the appropriate financial advising support, the appropriate therapeutic support in navigating this process. There's so many pieces, and going into it too blindly and trying to do things on your own, without feeling like you have a team behind you, it doesn't put you in a great position. So make sure that you have what you need.
You can make mistakes, right? Like you can make mistakes that you don't even know you're making. And I will say this too, when you're thinking about divorce, people think about divorce for usually 2 to 3 years seriously before they do it. You need to think about this, and it might not be your choice either. It might have happened to you. Someone else made that choice. You need to gather your resources, okay? And you need to gather your resources financially. Like, how am I going to pay for this, right? where am I going to live? What am I going to do? You need to gather your resources emotionally. Who is my support team, right? Do I have a therapist on board? Do I have friends that I know I can trust and talk to? Do people know what's going on, right? I'm not saying tell the whole world, like whatever, but make sure you know who your go-to people are. You know where your support is. Gather your resources financially, emotionally, and be ready to engage in the process and understand that it's a marathon, it's not a sprint. People get really frustrated. They want it over now. I have a friend named Rafe Palmer who has a book. He's a Chicago divorce attorney, and I think his book, I always say it a little bit wrong, it's I Just Want This Over. Of course you do. You want to rip the Band-Aid off, you want it to be done. But it's like the fastest result's not the best result. Fastest result, the first offer is probably going to say give the other person more property than they're entitled to. Take less time with your kids. Is that the best result? No, you have to live with this in this new era of your life post-divorce. And divorce can really be a chance for you to kind of start over and figure out what makes the most sense for you. But you have to understand it's going to be very difficult later to change your parenting plan. Don't agree to something you don't want, to change your child support unless there's a major change right away, to you can't divide property again. Once it's done, it's done. You don't get a do-over. So take your time and do it right and trust. You want to have trust in the people that you're working with. You're going to need a lot of people involved in most circumstances. Those custody evaluators I talked about earlier, you might need that, you might not. You're going to need probably somebody on the financial side that's going to get brought in, maybe to do some valuations. You might need an appraiser. Your attorney is going to know who you need and they're going to talk to you about it. But it's not just going to be you on an island. If it's you on an island trying to fill out some court forms, it's going to be, you're probably going to run out of water on that island and you're not going to want to be there. So that's just something for you to think about. You don't have to be an island going through divorce. I highly recommend that you don't. And even if you feel like, hey, I don't have the money for full representation, at least do a consultation with somebody, get an idea of what your circumstances might look like, figure out if maybe the other party has control over the money, maybe you have access to that, figure out if they're a friend or family that can help you get started. But you have to set yourself up for the next phase of your life, and it's just too big of a job to do alone in most cases. So I hope that that helps.
Bunch of questions. I'm just going to note that there are a couple in here that are really case specific, like specific breakdowns of custody plans and wondering about
No,
specific percentages of
we don't have
commitment.
time for that.
We're not going to be able to answer those
No,
today.
get a consultation with somebody, and because you really need to that I will say this, if you want to talk about should I be on a 2-2-3 schedule, should I be on a 50-50, should I be on an every other weekend, what about decision making, you need to talk to somebody and you need to talk about the specifics with your kids and your family. So I highly recommend that you do. There's a lot of different options, so you should consider that. I'm sorry, I wish we had more time. Also do go and watch. I'm pretty sure if you go to our website and you go to our YouTube page, it'll link you there. I'm pretty sure there's multiple parenting plan webinars where I might answer questions that you have. So you never know.
Okay, another question. What is approximately the dispute, the trial cost? If you're post a mediation failure and you're going into trial, what should somebody expect about how much trial is going to cost?
Well, if you're wondering how much trial is going to cost, I'm going to tell you this. It's going to depend on how many issues you have to resolve. Like, I'll give you this example. If you're just going to resolve, like, and this is the thing, if you have a good attorney, sometimes you can resolve some issues and not all, right? Like, ideally, most, I mean, I've been doing this a long time and I've had some really contentious cases. And still, I would say I resolve 90% or more at mediation. Most attorneys that do a good job do. But sometimes I've had a situation where it's like, oh, parenting's over here. We can't figure that out. Financials are here. A lot of the time, maybe we'll resolve some of the issues, but not all. So it's what are your issues for trial? Are you going to trial on all four? Are you going to trial on property division, like community property, maintenance, child support, and parenting? If you're going on all four, this is going to be a long trial and you're going to have a lot going on. How many experts do you have? Do you have a guardian ad litem? Is there a competing expert who's going to challenge the report? Do you have a financial expert? Do you have an appraiser? Do you have a bunch of people that are going to come in and say what a good parent you are? Like, how many witnesses do you have? How long is it going to take? How long was the marriage? How many people are there to talk about it? Like, I've had trials going for weeks. I've had trials going for one day. So it really, really depends. A typical trial deposit from a law firm is probably going to be anywhere between $25,000 and $75,000. So that sounds like a lot of money. It is. It's expensive. But here's the thing to think about too. you have, and this is where it all comes back to return on investment, right? Let's think about this. So if you're talking about, like, let's just say, and I'm not saying, I like to use this number because it's a round number. Let's say we're talking about $5 million, right? You've been married a long time. You've got $5 million in home, retirement, assets, all kinds of stuff like that, right? So what is a percentage of a $5 million community worth? 1% is $50,000, right? So 1% of $5 million is $50,000. So if you guys are, think about it, 10% off, right? Like your one person thinks I should get 10% less than the other. That's $500,000. Let's say you even were looking at trying to get half of that. That's $250,000. So when you're dealing with big numbers like this, and this is just an example, that $25,000 or $50,000 for trial, it doesn't sound like as much when you're talking about 500 or 250,000 or even $1 million or more, right? Or when you're talking about custody of your kids and where your kids are going to be living if you have serious concerns about the other parent, or you know what I mean? So, however, if you're fighting over $30,000, don't go to trial. Split the difference and call it good and keep the money. I mean, like, but what I'm telling you is trial's expensive because it takes literally hours and hours and hours of preparation. On the attorney side, there will be hundreds and hundreds and hundreds of pages of exhibits that are prepared for the court. There will be binders that are called trial binders that will have to be made. There will be hours where you'll be sitting with your attorney preparing for the questions they're going to ask you and what the other party's going to ask you. And that's why I was like, well, how many people are involved? Because that's going to determine how many days of trial and how expensive it's going to be. On the other hand, you could have a one-day trial on a very limited issue, like you've resolved everything but one thing. Maybe you have a one-day trial, and maybe that's not going to be as much. Or maybe you have a relocation trial about one parent relocating somewhere else. So it's narrow, and maybe that's going to cost you 10 or 15,000. I don't know. But it could really, really, really vary. But this is why preparing your case for mediation in the most meaningful way and preparing every case as if it might go to trial is really the best strategy, because it puts you in the best position to settle. And best case, if you're going to trial, a lot of the work is kind of already done for you. So I hope that helps. It's probably not what you want to hear, but it's reality.
Mhm, mhm. Okay, another question here. Okay, if a spouse bought a home 7 years before we got married, but now they've been married for over 20 years, he gets the house, or do I get anything when I help to pay it off?
Good question. The character of property is established at the time the property is acquired. So if your spouse bought a house 7 years beforehand and it's in their name and they acquired it, it's their house. The character of that property doesn't change just because you lived there and got married. There is a case, there's a very specific case where it even says if the community paid the mortgage while you were living there, you received the benefit of living there. You would have had to pay rent to live somewhere else. So you're not getting any kind of principal pay down, or if the mortgage was paid and your spouse used their community funds to pay it while you guys were living there, well, you got to live there, so you received the benefit. That's different though than, let's say, you were living there, it was still a community house because it was bought 7 years before, and you and your spouse take $100,000 in community money and make a huge lump sum to pay it off. Then you might have what's called a community lien. There might be a community lien on the property because you helped actually make like more than just mortgage payments to pay it off. If the mortgage was just paid though while you were living there, you got the benefit of living there, and the character of that property didn't change. Now, if your spouse bought that property 7 years before marriage, and let's say in the middle of the marriage, they decided to refinance the property for better rate, and they put you on it and your credit helped with it, and then you took on debt. Then the house was what we call transmuted from separate property now into community property, because we have a writing and we have an intent for it to become community in most cases. So you can change separate property to community property through commingling it or transmutation, which are both specific legal doctrines you'd need to talk to somebody about. But otherwise, the character of that property is established when it is acquired. You might have an interest in it, by virtue of lien or something else if there were extraordinary circumstances. But if you just lived there and the mortgage was paid down, then you don't have an interest in it now. I mean, that's just a general, basically rule of thumb analysis, very high level analysis based on Washington law, but I hope it helps.
Awesome.
I'll take one more.
Okay, yes, we are having to wrap up here in a minute. All right, let's see. I'll try to find something that feels like it would be a good one for everyone. This is kind of important general question. So what options are available when one party voluntarily takes a lower paying job during the divorce proceedings, but then gets a higher paying job after the divorce is finalized? You know, is there a threshold for how much additional income someone can earn before it starts to impact, you know, obligations or modifications?
No, I mean, you made here's the thing, maybe with child support, but you made an agreement when you finalized your case. And this is why you need good representation early. Because if your spouse took a lower paying job than they've ever taken during the divorce, or they quit their job, you should be asking for that spouse to be imputed to their last known income. And you should be making that argument. Because once you agree on a maintenance award, it's very difficult to change it later. Typically, in most cases, it's not going to happen, that it's going to change. You've already made the agreement. You're done, right? You don't get a do-over. Now, if you are the one paying maintenance and you lose your job and it's not non-modifiable, which needs to be specified, you might be able to restructure maintenance, and you're still going to end up usually paying the full amount. You just might have it delayed until you get a new job. But if you're the one that's receiving maintenance and you already agreed to something and that person goes and gets another job later, I mean, they can do whatever they want later. The issue is during the divorce, if they took a lower paying job, like to pay you less, you got to deal with that then, and you've got to seek imputation then. So that might not be what you want to hear, but I hope that helps. I'll take one more because I've got 4 minutes, and then I'll give you my wrap up.
Okay. Is there anything valuable or recommended about a statement or a declaration from a therapist for the court record?
I mean, not unless, I mean, yes, if it's relevant, like if your mental health is being called into question, or there's a question about your parenting, or something in that realm, then yeah, if your therapist is willing, your therapist is also going to have to talk to a guardian ad litem, and you're going to have control over what they share with, you're going to have control over what they share with the guardian ad litem, because obviously you have confidentiality. But some therapists won't make a declaration for you. They won't get involved. They will refuse, and that is up to them. It can be very difficult, though. So in some circumstances, yes, it can be very beneficial and very helpful. But just putting a declaration from a therapist in a court file is also not helpful right off the bat, unless there's a specific reason. Just like anybody, you don't want just random declarations in the court file. Number one, no one's going to read them, and number two, they're not relevant. And number three, they include personal information. So if you do have somebody making a declaration like that, it might need to be filed under seal if it contains personal health care information. So you need to be very, very careful about those things. So I hope that helps. Anyway, we went over a lot of things today. We talked about who can file for divorce. We talked about, what the waiting period is. We talked about the 4 main issues in divorce. We answered some of your questions. So we talked about a lot. And guess what? Like, I could talk for probably 5 more hours easily about this without pause, giving you more information on the process and different things you need to know. So I'm not going to do that today, but I encourage you to look at our video library. There's a lot of time there. You can watch me talk for hours about things if you want. But really what I recommend you do is you look for the topic that's interesting to you or relevant to you, and you watch it, and that you come to our webinars, that you attend our meetup group. That's every month. At the end of the month, we hold them once a quarter in person. Otherwise, we hold them online. It's a really good opportunity to ask questions and engage with other people. That's really helpful. But more than anything, I recommend that you schedule a consultation about your own situation if you can. It doesn't have to be with us. We do have at our firm, we have 15 family law attorneys. We have a full support staff. All we do is family law. So if you want to talk with us, we're happy to talk with you. I'm happy to talk with you, or an associate on my team can. But really any family law firm, I don't care who it is, go and talk to somebody about your situation and get your questions answered, at least in general, for what may or may not make sense to you, because this is your life. This is your next step forward. And I wish you all the best taking it. We'll see you next time. Thank you.
Thanks, everyone. Yes, definitely reach out. And if anyone's interested in counseling, feel free to reach out to me as well. We wish you well. We appreciate you coming today. Thank you.